Ready, start. It is for this purpose that the provisions of Section 6 of the Specific Relief Act, 1963, Section 145 of the Code of Criminal Procedure, 1973, and Sections 154 and 158 of the Indian Penal Code, 1860, were enacted. Full stop. All the aforesaid provisions have the same objective. Full stop. The said presumption is read under Section 114 of the Evidence Act and applies only in a case where there is either no proof, or very little proof of ownership on either side. Full stop. The maxim possession follows title close is applicable in cases where proof of actual possession cannot reasonably be expected, for instance, in the case of wastelands, or where nothing is known about possession one way or another. Full stop. Presumption of title as a result of possession can arise only where facts disclose that no title vests in any party and the possession of the plaintiff is not prima facie wrongful. Full stop. It certainly does not mean that because a man has title over some land, he is necessarily in possession of it. Full stop. It, in fact, means, that if at any time a man with title was in possession of the said property, the law allows the presumption that such possession was in continuation of the title vested in him. Full stop. A person must establish that he has continued possession of the suit property, while the other side claiming title, must make out a case of trespass slash encroachment, etc. Full stop. Where the apparent title is with the plaintiffs, it is incumbent upon the defendant, that in order to displace this claim of apparent title and to establish beneficial title in himself, he must establish by way of satisfactory evidence, circumstances that favor his version. Full stop. Even a revenue record is not a document of title. Full stop. It merely raises a presumption in regard to possession. Full stop. Section 113 of the BSA, as discussed aforesaid, embodies the principle that possession of a property furnishes prima facie principle of ownership of the possessor and casts burden of proof on the party who denies his ownership. Full stop. The presumption, which is rebuttable, is attracted when the possession is prima facie lawful and when the contesting party has no title. Full stop. The appellants could be said to have established their possession over the suit land in question right from the year 1970. Full stop. There is cogent and convincing evidence in this regard. Full stop. They were in peaceful enjoyment of the suit land in question. Full stop. In our opinion, the respondent state has not been able to prove its title to the suit land. Full stop. Just because the suit land is surrounded by few other parcels of land owned by the government, that by itself will not make the suit land of the ownership of the government. Full stop. If the government claims title over the land, it has to establish it by producing relevant records in the form of revenue records, etc. Full stop. In our opinion, the state has failed to advance any credible evidence on record to rebut the presumption. Full stop. Consequently, the appellants have pattadar's title to the suit land in question. Full stop.